back on the record on case number 2020 CF 2361, State of Florida versus Shaver. And at this time, we'll address the pending motions. Is there any specific order that the parties would like to proceed?
Judge, if we could start with the state's motion only as to the delay in charging.
All right, we'll just proceed in the order listed on the notice of hearing. So, number one for the state is the motion in limine as to delay in charging the defendant and decision not to charge all the defendants. Please proceed.
Thank you, Your Honor. Primarily, I'm going to rely on my motion. I'm sure the court has read it. But there's no question that there are states are going to be mentioned. The jury's going to know that the remains were found in 2018 and the charging decision based on the date of the information is after that. The focus of the state's motion is to prevent the defense from arguing to the jury or trying to elicit through any detective or witness the reason behind the delay in charging. That information is exclusively within the purview of the state attorney's office and the prosecutor's office. The state has exclusive authority to determine how to charge, who to charge, when to charge. That all lies in our inherent statutory authority. To interject any suggestion of the reason why the defendant was not charged immediately interjects completely irrelevant evidence. It would then introduce a need or requirement for the state to possibly call the prosecutors involved in this case to explain what was going on, when we received information, why we made decisions that we did, all of which are again within the purview of the state attorney's office and not relevant. If that evidence were to be admitted or allowed to be argued, that would in essence put myself, Mr. Camuccio, potentially now Judge Emily Currington, because she was involved in this case at some point, into the witness list of having to testify and explain those decisions, potential changes in the law which could have impacted the decision to file, and none of which is at all relevant as far as whether or not Ms. Shaver committed these crimes. For the remainder of my argument, or line of motion.
All right, Mr. Williams,
Yeah.
have any objections?
Please support. Judge, I don't agree with that. We wouldn't concur in that. The jury is instructed that the state has power in the investigative process, but the manner in which the case is investigated, the time in which it's investigated, the manner in which it's investigated speaks to the weight of the evidence, the credibility of the evidence in this case, which is fair comment by the defense. To just say, you can't talk about these things, we got providence in this area, it invades the defendant's right to argue the merits of the state's case. Obviously, if the evidence was overwhelming at the very outset, Ms. Shaver would have been charged. So it goes to the weight of the argument that we're able to persuade the jury. It doesn't deal with the powers of the state. You're just invading providence and the privileges of the defense and making fair comment at trial.
All right, Mr. Buxman?
I think Mr. Wiggs may have misunderstood the purpose of my motion and my argument. Clearly, the manner of investigation is relevant. My motion was limited and focused solely on preventing the defense from getting up and arguing. It took the state X number of years to charge the defendant, therefore they must even believe she's not guilty, or something to that effect. The questioning or implications of the state's reasons for the delay in charging, not the investigation.
No, I understand it quite clearly. The state's just saying, if you want to deal with time, you can't talk about it. Okay? No, we want to be able to talk about it as to how this
relates to the state's charging decision. Is that correct, Mr. Buxman?
No, not to the charging decision, as to the time. The state has spoken that as to exclude, I think, the time it took for them to investigate the case and make the filing decision. And the state was saying, well, that would cause us to have to call, for me to have to take the stand, et cetera, et cetera. Well, the evidence is presented to the state at some point. But what law enforcement did, how they investigated it, how long it took them to investigate it, and then deliver it to the state, and how long it took the state to make decisions. Those are all fair argument for the defense. The jury, as part of the instructions, is instructed to rely on your common sense and reaching their verdict. That goes to how the manner of the case was investigated, put together, and how much time it took them to reach the decisions that ultimately Laurie Shaver sits here on this information. So those should not be barred from comment, Judge.
All right, anything further?
No.
For the limited purpose requested by the state, the motion in limine is granted.
And to what extent, Judge?
Regarding the state's filing decision and the timeline that the state took.
Okay.
Now, law enforcement investigating the case and how long that took is a separate issue.
Okay, so we can discuss how long it took law enforcement
Yes,
to
sir.
investigate. Okay.
All right, we can move on to number 2. State's second motion is the motion to strike defendant's notice of intent to rely on business records.
One second, Judge, I'm
Yes,
sorry.
sir. Let me know when you're ready.
Okay. The next one is what that we're taking up?
Next one on the notice is motion to strike defendant's notice of intent to rely on business records.
Your Honor, Nick Muccio, I'll be arguing this issue.
Yes, sir.
We have had a similar hearing on these specific documents already as it related to Mr. Wiggs's attempts to have the court take judicial notice of the contents of the domestic relations injunction, as well as the state's law enforcement report from the 2014 domestic violence case that they have referenced at various points. I had also filed, because they filed notice of intent to allow business records certifications to try to get those documents in. I filed motions to strike that because the reports themselves just are not admissible in that fashion. I've supplied a subsequent memorandum of law that specifically references police reports and DCF reports and how the tool of notice of intent to allow business record certification is improper to get all of that information in, as it is filled with various hearsay and inadmissible evidence. As I stated at the hearing involving their attempts to get this evidence in through judicial notice, I am not saying that they cannot bring up issues of the injunction or the domestic violence arrest from 2014. However, simply putting in reports that are filled with nothing but hearsay is not the way to properly admit that evidence before the court. So I filed the motion to strike the notice of intent to allow business record certifications, as that is not a proper vehicle to admit reports. Throughout the proceedings of this case, Mr. Wiggs has marked various reports and portions of reports as exhibits for purposes of hearing, and I have repeatedly talked at those times about how that would not be appropriate exhibits for trial, but for purposes of those hearings it was permissible. I am also aware that Mr. Wiggs has attempted to just mark reports and depositions in trials in front of this court, and as attempts to just wholesale put those exhibits in, which is improper. So my memorandum of law, as well as my motion, fully outlines all of the arguments, but that is what the basis of this is.
All right, thank you, Mr. Wiggs.
May it please the court.
Yes, sir.
Judge, with regards to this, I thought the court has already ruled on this matter as to the arrest of Michael Shaver and spoken about this and ruled on it at this stage. So I don't know if Mr. Camuccio is asking the court to rule on something that's previously been ruled on at this stage. That I'm not certain. I understand that there's a predicate that has to be laid for the introduction of evidence. I'm aware of that, but I believe you've already ruled with regards to Michael Shaver's conviction and the domestic violence issues at this stage. We haven't moved at this stage to seek to introduce any evidence at this stage, but I believe you've already ruled on it, Judge.
Well, Mr. Camuccio, do you want to differentiate between what was ruled on previously and what you're seeking now?
Yes. The previous hearing that we had was the hearing that we dealt with that was titled, Mr. Wiggs titled Reverse Williams Rule. And there was a request for judicial notice of various items in the court file, including the injunction as well as the police reports. And the court had ruled already that those documents could not come into evidence through through judicial notice. We have repeatedly said if witnesses that were actually involved in these incidents were to come forward and state this is what happened, that is the correct way of putting this evidence in before the jury, not just putting in a police report and having that be, as a matter of fact, what happened on that night. This particular filing is because not only were they requesting the court take judicial notice of those documents, they filed notices of intent to rely on business record certification to move in the records from 2014 DR 1502 and 2014 MM 5308. So this motion specifically is saying that they should not be allowed to put in those records as business record certifications based on their notice, and the statute specifically says that if a party files the notice of intent to rely on business record certification, if opposing party has an objection to that, it has to be done before the trial, so that if generally the procedure would be, so if there is an issue with the notice itself, if the party wants to bring in the live witness that would be the business record custodian, they could do so that way, as opposed to finding out in the middle of trial that opposing counsel had an objection to it. My objection is stated that these records are not admissible as business records, so therefore the notice of intent to rely on the business record certification are invalid. And my motion talks about how not only is there hearsay, but whether or not the clerk's office is actually the party that actually creates these records and maintains these records. They're not. They just take what is given to them and puts it in court files, so therefore they are not actually producing any of these business records, any of these records that he claims are business records. So yes, we have had a hearing. Yes, there has been determinations that certain areas of the injunction and the county court case are going to be admissible, but not simply by putting in police reports, domestic violence injunction petitions, and things of that nature.
Judge, we didn't intend to do that, but I think if you look in your order, I think it's paragraph 16 and 17 is where you address it. And it states if you can lay a proper predicate. Okay? You'd already ruled on this. The state is just filing this late and now raising it a second time, but you've already ruled on it. You've stated, Judge, if you can lay a proper predicate.
Correct. And that was previously stated, but to the extent that Mr. Camuccio has cited or distinguished the prior ruling from the present request, the motion is granted.
Thank you, sir.
Okay, we move on to number 3. And state's third motion is notice of intent to agree to enter a summary and memorandum of law attached to it.
Yes, well, yes, Your Honor. This is simply dealing with the various IP records that have been that were compiled from the Facebook records themselves for the courts. So the court is aware the state is intending on admitting the Facebook records both from Michael Shaver and Laurie Shaver. We've had hearings on the relevance of all of those already. It is my intent to put in the entire IP logs of both Laurie Shaver and Michael Shaver Facebook records, so the jury would have access to all of the information. The evidence summary that I've filed that is in compliance with Florida Statute 90.956 simply summarizes some of that information, and it is a permissible tool to help assist the jury in understanding all of the records, but they will also have all of the records themselves, and they're fully able to go through and look and see that, yes, all these IP addresses and times and dates and numbers and all of that matches up. It is a summary as the rule allows, to allow them to process pages and pages of information, but all of that information will actually be made available to them.
Mr. Wicks?
Yes, may it please the court.
Yes, sir.
Judge, we would contest to this, and I bring to the court's attention, and I'm going to get the status summary. There's some private notes on it on the top that give the court a summary that deals with stacking inferences again. This goes back to stacking inferences. We had addressed this at a hearing, and it was our position that it was impermissible to stack inferences. The state was of the position that it's permissible to just throw everything before a jury. Basically, that Bush had just done away with the concept of stacking inferences. So what the case I gave you deals with is, it's a statement of the law recently announced and the case cited. And that case is Smith versus Carlisle. It's a 24 decision. And it goes back and it addresses stacking inferences. And it goes through all the cases we discussed. It goes through Bush. It goes through Knight. It goes through Law, the cases that I relied on. But what it points out is really the state wasn't properly correct, and I wasn't entirely correct as well what I'd represented before the court. What the case did is it said, well, Bush did do away with the concept of stacking inferences, so you go back to the original case where this was addressed, which is Volcker versus Combined Insurance Company of America, 73 Southern 2nd 403, a Florida Supreme Court decision of 54. So that was reinstated by the elimination of Bush. And the court states this within it. The Supreme Court, stacking one inference upon another as a method of establishing an ultimate fact ordinarily should not be indulged in unless the first inference meets a test which may be analogized to the criminal rule concerning circumstantial evidence. And it proceeds thereafter and says, only if the prior or basic inference is established to the exclusion of any other reasonable theory. So the decision declares that basically, yeah, you can stack inferences, but your initial inference that you're going to build on has to be subject to no other reasonable inference. So the state can go and proceed and say, you know, we're going to just build it from there. Of course, then the jury is just told to weigh the credibility of the evidence on their own. There's no special instruction anymore. So now to take their position now that they want to stack an inference, go back to stacking inferences, what they've done is they've taken a summary. And the court has said, yeah, okay, you can use these records. But Judge, they still, just as Mr. Camuccio just stated in the last motion, he said, you still have to lay a proper predicate, Mr. Wiggs. And I said, yeah, I know that. And that's what the judge ordered previously. So you can't take a summary when the facts are of dispute, which they are, okay, digest a bunch of facts into a summary, put it before a jury and say, accept our version of these facts, okay, that's what we want you to use. That would run afoul to the case that I cited before the court previously, which is the Supreme Court decision, Yisrael, and the motion for to exclude the digital data that I cited. That case, you'll recall, Judge, was a case wherein the state prepared a document through the Department of Corrections as to the release date of the defendant, and then tried to move it in as a business record for purposes of habitualizing them. They said, no, that wasn't a business record. You generated it after the fact, as they do here, to summarize facts and put it before the jury and say, this is our version. You have to accept this version of the evidence. Well, what they're doing is trying to establish a predicate. The state acknowledges they still got to establish a predicate. Now, in the motion for digital data, to exclude it, I set forth, I think, 4 different predicates that have been recognized in this state, and that was through the case, I think, Walker versus Anderson, that's cited in the memorandum. And all of them establish one common theme, as I announced to the court, that there has to be a tight connection in multiple manners between the facts and the defendant, excluding all other reasonable probabilities and possibilities. So to just sit there and summarize some fact, put it before a jury, and say these are all clearly discernible from the evidence that we're going to introduce, disregard anything Mr. Wiggs has to say, or any expert, or anybody else he has to offer you, and accept this, and then tell the court we've established a predicate, that's impermissible. You're generating facts after the fact, trying to use it as a business record, and then establish a predicate at the same time. That's only proper when the facts are not subject to dispute between the parties, that you can admit a summary in that manner. So we'd object to it on those grounds. The defense likewise would point out to the court that proceeding in the manner that the state would suggest would preclude the defense from being able to examine each witness as they dealt with the evidence, the digital data, how they got it, what they did with it, how it came to it, and would deprive the defense of a right of confrontation and cross-examination under the law. So I advise the court, Judge, that one, the state can stack some inferences to try to reach that predicate, but one, the standard is a higher standard than the state may assume it is. And on these grounds, we'd ask that the state's motion at this stage be denied.
Mr. Commissioner, do you wish to respond?
Couple things. First of all, none of the stuff that Mr. Wiggs is arguing has anything to do with what this motion is requesting. It is saying that these records, which have been determined in a pretrial ruling, are relevant, that we are taking the data from them and compiling them into a chart. That's all this motion is saying. What he is talking about deals with potential JOA arguments, and when he starts talking about the stacking of inferences. This request simply talks about compiling data that will be in front of the jury and putting it into a chart. That's it. Mr. Wiggs, please don't interrupt me.
I'm sorry, counsel. You don't need to get upset.
The other thing is, this is not the first time we have been presented with, quote, case law without any sort of citation. I have absolutely no idea why Mr. Wiggs did not actually just give you this Smith versus Carlisle case that he says is from 2024 and instead just gave you his memo about it. But this doesn't even include a site for us to look up. I would ask that any case law that Mr. Wiggs is referencing or trying to have reference in any sort of legal argument, at the very least, he provide us the actual citation and put it on the record.
It's on the case I gave you, the document I gave you, if you'd look thoroughly through it. The case citation is 378 Southern 3rd 1213. The other decision is cited within it as well.
That's all, Judge.
Thank you, sir. Do you wish to respond, Mr. Wiggs?
Yes. The Volcker case is cited right in there, okay, as I just stated. Smith versus Carlisle is the decision of 2024, okay? Now, that's what cites Volckermer. It's a 24 decision I pulled off of Florida Law Weekly. It's a current decision, okay? But Judge, going back to Mr. Camuccio's argument, he's stating that just providing a summary is not damaging to the defense. It is damaging because you're emphasizing particular facts only for the state. You're giving them a summary. I don't think Mr. Camuccio would agree that I could create a summary of Richard Connor and put that into the record as well, as to what his take on it all is. So, no, it's not appropriate. You're emphasizing facts. Now, the law that he has cited in his motion to grant that is when the parties stipulate these facts are undisputable. Okay? That's when a memorandum or a breakdown summary is appropriate. But those facts are of dispute. You heard Richard Connor. Richard Connor stated that you can't link the IP up with the digital data because it expired. I don't think the state's going to put that in a summary, okay? Richard Connor said all that data is expired. It can't be linked to a device, a location, or an individual. And that anybody that used a router had access to that same system. But at this stage, none of the data links to an IP address. And so we heard technical testimony on that, of which the state didn't refute at that hearing. I would point out to the court. I talked to the court and I said, these are the foundations, these are the predicates, of which the state offered no evidence, how they would try to establish a predicate at trial. So the only thing they did is they ushered in a bunch of documents and said, these are a business record. Now they're seeking to develop a predicate through a summary, of which the state just objected to the plausibility of the defense doing the same. So it should be denied.
All right, anything further?
No, sir.
State's motion is granted. The state may admit evidentiary summaries pending proper foundation. We'll move on to number 4. And state's number 4, fourth motion is a motion to prevent exclusion of witness. Please proceed.
That's not, yeah. That's not.
Yes, Your Honor, this is pretty pro forma, pretty standard. The victim's father in this case, Laurie Shaver, has requested to be present during the trial. He will be called as a witness, probably towards the beginning of the state's case. The Florida statute that I cited in my motion indicates specifically that the next of kin may not be excluded from the courtroom during this type of a trial. So we're just asking that Mr. Shaver, being the next of kin of Michael Shaver, be permitted to watch the trial.
Because we don't have, and I know that there's a discretionary concept with that same rule that allows the court discretion in whether to grant it or to deny it. We don't have any problem with Mr. Shaver sitting in during the trial. We would ask the court to instruct Mr. Shaver that he's not at liberty to speak to anybody during the trial about anything that he hears heard within the courtroom. And that the rule of sequestration would still be applicable to him even at the conclusion of his testimony, because we're not going to release him.
All right, as a stated agreement?
Yes.
All right, then, without objection, a motion is granted.
Thank you, Your Honor.
All right, and the state's fifth motion is state's response to defendant's motion for presence of prospective jurors during entire court diary process. So this goes to Mr. Woods' motion to permit the venire to be present when we are at the bench selecting the jury members.
What I've asked judges that they remain in the courtroom during the entire voir dire. And I've expressed in the motion the basis for this. I know the state didn't voice any objections, saying they'd leave it to the discretion of the court, but the concepts were to allow the witness or the defendant not to be confused, be able to look at the prospective juror to the conclusion, know if they want that witness, just like any witness on the stand has a right to be refreshed at any stage by looking at anything. We'd ask that the prospective juror remain in the courtroom. Second, we've done it historically as a matter of practice. Further, we have the white noise sound system that precludes any invasion or any fear that the prospective juror is going to be somehow tainted by us discussing matters at the bench. So I don't think there's any danger in it. But I think it's a necessity in a trial of this fashion and the size of the jury.
No, I did not ask to leave this in the discretion of the court. I specifically stated that the state requests that you deny their request. Mr. Wiggs definitely seems to have a habit of citing case law that is not actually have anything to do with the issue at hand. For this matter, he has cited cases dealing with refreshing the recollection of a witness, which has nothing to do with jury selection. He has also cited case law about that deals with 3850 claims dealing with whether or not an attorney should have stricken a juror who had, through his statements, shown bias. He does not cite anything that has to do with the issue that he wants the court to do, which would be the rule of criminal procedure, which states that these strikes should be done outside of the presence of the jury. The issues that...
Outside the hearing or outside the presence?
Outside the hearing. I apologize.
Right.
However, I think it's important to remember that our job here is to maintain the best record possible so that if this is ever transcribed, that the court reporters can go ahead and actually hear what is happening. I pulled the jury selection from the case where this court actually allowed the procedure as outlined by Mr. Wiggs. And I have the recording of that if the court would like to hear it for itself. I would say that it is much more difficult to hear the bench conference when people are whispering and trying to maintain the spirit of this rule while we are up there doing strikes and having the white noise sound played, as opposed to if we were sitting out here in front of microphones and actually establishing what our reasoning for challenges might be and any sort of legal argument that we may have. Any sort of due process claim fails because it is exactly the same for both sides, whichever route we go. But I believe that it is much more important to make sure we have a clear record of what the legal arguments as to any sort of juror strike should be than anything that Mr. Wiggs has outlined in his motion.
May it please the court.
Yes, sir.
Judge, I don't know if Mr. Camuccio just doesn't understand the concept I'm arguing, but to say that the person can be refreshed, yes, that's a statement that I made in the motion by analogy. No, there's no clear case law on this. There's not. It's a discretionary matter with the court. I didn't see any case law or any argument by the state otherwise. The legislature has approved this white noise system. If we go by what Mr. Camuccio is saying, we'll just eliminate it, Judge. We'll never have use of it again in a courtroom. But I don't think that's the concept or the principle that the court wants to follow. But I stated in my motion that any witness, by comparison, any witness on the stand, if they're not refreshed at any stage, they have a right to look at anything to refresh themselves. So I said, comparatively, by analogy or argument, why is a defendant, why would you take all the jurors out of the room and have a mass of jurors sitting outside when you're doing back strikes and you've got multiple strikes in total, and leave the defendant confused. I've sat there, and people are asking me sometimes when they are removed from the courtroom, well, what's that person? Who was that person? Was that the teacher? Was that the this, that? And you spend more time trying to keep track of where people are seated, which can raise a 3850. Okay, and I said that in my motion. You got to only greaten the odds that you may have a problem down the line on an appeal because you just didn't impose a safeguard and leave them in the courtroom. So I don't know what policy the state thinks they're advancing here to object to this, but I see that there's a warranted and a healthy process leaving the jury in here instead of returning and seeing it up on an appeal and having to readdress the issue again.
All right, I'll grant defense's motion. I'll allow the venire members to remain in the courtroom during the entire jury selection process. Okay, we're on to state's number 6, which is state's motion in limine regarding expected testimony of Adam Narvaez.
Yes, Your Honor, Rich Buxton, thank you.
Yes, sir.
The state's motion really focuses on two different things. The state deposed the defense listed Mr. Narvaez as a witness. The state deposed him. I attached a copy of the deposition to the motion for the court's benefit. The state's focuses on two separate sets of statements made to Mr. Narvaez. The first set of statements are made to him by the defendant, Laurie Shaver. Mr. Narvaez indicated that Ms. Shaver, the defendant, told him that she and the victim had a rocky relationship and that there had been a history of abuse. Those statements the state is seeking to exclude because they're clear self-serving hearsay. As we all know in this room, the statements or admissions against a party opponent are admissible, which is why the state is able to introduce the defendant's statement against her. These are self-serving statements. They are inadmissible and can't be presented through the defense by asking the witness, did the defendant tell you X, Y, and Z, or asking the witness, what did the defendant tell you? I've cited the 3 cases of many that apply to self-serving hearsay in my motion. This concept would also apply to any witness that the defendant made similar statements to, not just Mr. Narvaez, but because my motion is focused on Mr. Narvaez, I'll limit my discussion to just that. The second portion of the state's motion focuses on statements made by the defendant's daughter, Isabel Shaver, to Mr. Narvaez. As we know, the defense is going to potentially be that Ms. Shaver, Isabel Shaver, was the one that actually shot the victim. Ms. Shaver made statements to Mr. Narvaez years later indicating such. Those are clear out-of-court statements made by a witness, Ms. Isabel Shaver, to Mr. Narvaez, used to prove the truth of the matter asserted, so they are clearly hearsay. By no means is by the state's motion are we trying to prevent Ms. Isabel Shaver from testifying. That's not the focus of the motion. The focus of the motion is to prevent witnesses from being questioned about hearsay statements made by Ms. Isabel Shaver. So, because statements made by Isabel Shaver to Mr. Narvaez are clear hearsay, the question is there a hearsay exception to those statements? And the only exception potentially that could be raised is that it's a statement made by the declarant against the declarant's penal interest, pursuant to 90.804(2)(c). In order for that hearsay exception to be established, the defense, because they're the proponent of the evidence, would have to prove 3 things. Number 1, the declarant, Isabel Shaver, is unavailable. Well, we know that's not the case because Isabel Shaver has given a deposition, and by everything I know, she is ready, able, willing, and is going to testify in this case. So that prong cannot be met. Therefore, the exception for a statement against penal interest cannot be established. You don't even have to get to the second and third prongs because, again, Ms. Shaver is available. If you do want to go into further analysis, and which you don't need to, but if you did, the statements are also unreliable. Again, I don't think you need to get this far in the analysis, but they are unreliable considering that Ms. Shaver was questioned refuting her statements as well as the testimony of Jeremy Townsend. But again, I'm not going to go into that really in detail because, again, the state's position is Isabel Shaver is available, therefore prong 1 of this cannot be met, therefore the exception doesn't apply and the statements are hearsay. Pursuant to my ethical obligation, there is a line of cases which I included in the motion, which talks about constitutional due process, and that is the Chambers versus Mississippi case. And I included that because I felt the court needed to be aware of it and needed to at least know about it, so I wanted to make sure the court was aware, and the defense wants to argue this. But it's important to note the Chambers versus Mississippi case cites 401 U.S. 284, 1973 case. That case addressed a Mississippi case in which a third party confessed to a murder to several people, but then recanted the confession. The state obviously did not call this witness for clear reasons. The defense then tried to call that witness and impeach the witness on the statements he made confessing to the murder to other people. Mississippi had a rule which prevented the defense from impeaching their own witness. Florida doesn't have that rule. So the defense could not get the information that this third party confessed to a murder out by calling the witness and impeaching the witness. So then the defense in Chambers versus Mississippi said, okay, we're going to call those 3 people that the witness confessed that he committed murder to. So they called those witnesses, and the problem with that was it was hearsay, and Mississippi did not have an evidentiary provision allowing, like Florida does, allowing for a declaration against penal interest. So the defense wasn't able to present that information through those witnesses. So because of those voids in Mississippi's evidence code, the U.S. Supreme Court said that the defendant had a constitutional due process right to get the information to the jury, and the evidence code that was in place in Mississippi did not allow that to happen. So what Chambers in Mississippi versus Mississippi basically did was say, on a constitutional due process ground, they allowed those statements, even though they were hearsay, to be admitted to the jury because the defense had no other way of getting that information before the jury, and the U.S. Supreme Court said that's not fair from a constitutional due process. Florida has these provisions, unlike Mississippi. So Florida's evidence code distinguishes Chambers versus Mississippi in that line of cases from the case we have here, this instant case. Chambers pointed out that its holding was not establishing new standards of constitutional law and was not dismissing the authority of the states over their own trial rules. So Chambers didn't find that the evidence code is meaningless and we're going to throw it out and let everything in. Jones v. State, in Florida case, 709 Southern 2nd 512, it's a Florida 1998 case. The court cited Gudinas, which was 453 Southern 2nd 17, Florida Supreme Court 1984, which said Chambers was, quote, limited to its facts due to the peculiarities of the Mississippi evidence law, which did not recognize a hearsay exception for declaration against penal interest. So our Florida Supreme Court basically determined that Chambers wasn't applicable because Chambers was meant to fill that void in Mississippi law that Florida did not have. In this case, the defense has every ability whatsoever to present this evidence to the jury, which Chambers couldn't do, but the defendant does because they can call Isabel Shaver and talk about whatever Ms. Shaver wants to say. So that evidence can be presented to the jury by simple traditional methods of calling a witness. The state's focus is, again, not to prevent Isabel Shaver from testifying or limiting her testimony like in that fashion. The state's focus is to prevent the defense from questioning witnesses about the hearsay statements made by Isabel Shaver to Adam Narvaez. Thank you, Your Honor.
Thank you. Mr. Wicks?
Yes, ma'am, please support.
Yes, sir.
Judge, we're not offering testimony of Mr. Narvaez to speak about the truth of the statements of Isabel Shaver, but the circumstances under which Isabel Shaver has come forward. There's inferences and allegations that, so to speak, she was called late in this game. The record shows she was not, that Kelly Johnson was appointed as a consequence of her moving forward. Mr. Narvaez, his involvement was he spoke to Isabel and then had a talk to Laurie Shaver, and thus there was a consensus at a certain stage to allow Isabel to move forward with their testimony. Thus, that's how Kelly Johnson got appointed as her guardian and went through the steps that she did. It's just to show a sequence of steps as opposed to putting a witness on the stand as if we've just pulled her out of off the street. It just shows a sequence of events with the timing. It's not to prove the truth of the statements of Adam Narvaez, but to show the timeline and why the minor child stepped forward. That's why. And that's a non-hearsay purpose. You know, it's not to just show that she told me this, okay? It's, you know, what happened beyond that point. So that's the reason it would be offered,
Yes, sir.
which is non-hearsay.
State's response?
It's being used, if they're eliciting statements made by Isabel Shaver out of court that I shot my father, that is being used to prove the truth of the matter asserted. That's the whole point of it. To explain the circumstances surrounding it is not a valid purpose. That's like me asking a detective to talk about hearsay because it establishes, you know, that's like me asking a detective, who did you talk to and what did they say, just to establish the context of the investigation. That's clearly hearsay, and this is no different.
The testimony has not been proffered. Now, the state is saying this is what the child's going to say, and this is how she's going to say it. Judge, I think the state is getting ahead of themselves, assuming everything is hearsay that child could say. The context in which the child makes those representations defines whether it falls outside of the hearsay rules. But the state's saying that child told Mr. Narvaez, I did X, Y, and Z, and then, you know, she's offered as a witness. Okay? No, that's not the context in which those statements will come forward. She confided in Mr. Narvaez about certain facts and events. She confided in Mr. Narvaez about her desire to testify and come forward because of her emotional feelings in this case. That's not hearsay. It explains a timeline and why this child is going to be here testifying. That she's not being thrown under the bus, as the state may suggest, but that there's a rational basis and a timeline why she stepped forward.
All right, is there anything further?
No, sir.
All right, I'll grant the state's motion. The court finds that any testimony regarding the timeline is hearsay, and the court will make the appropriate hearsay rulings at trial.
Yes, sir. Thank you.
I believe that leaves us with Mr. Wiggs's motion, which is a motion to request judicial notice of the contents of the clerk's file.
Yeah. Judge, I filed just as a standard motion asking permissive judicial notice. I don't know exactly what's going to be presented by the state. You'd ask the state to try to work with me and tell me what exhibits they want to use at trial. Today I confided with the state whether they would do that. Mr. Camuccio says he hasn't figured that out, so I presume that's a no. Okay, so at this stage, I don't know what the state may show, but it may open the door to the introduction of other evidence. So I'd ask the court to leave that door open for permissive judicial notice at trial.
All right, state's response?
Your Honor, we obviously don't have any issue with the fact that the documents within the court file themselves are authentic for purposes of request for judicial notice, but that is not an avenue for admissibility. Just because it's in the court file doesn't mean he can just say, this is from the court file, so jury, here you go. As I said previously, Mr. Wiggs does appear to have a habit of, in front of the jury, referencing and marking pieces of evidence that clearly are inadmissible as far as reports and depositions, and then requiring the state in front of the jury to object to things that are just clearly inadmissible. If he wants any of these items marked, or if he thinks any of these things have been opened up the door to admissibility, I would just ask that outside the presence of the jury, that be proffered as to what the document is and the reason for how it is now admissible, because simply because it is in a court file or in this court file does not make it evidence in this case. And all I'm asking is outside the presence of the jury that be proffered.
If Mr. Camuccio read the motion, he'd see it's a request for permissive judicial notice, not mandatory judicial notice. I'm not going to be throwing things at a jury judge here. I did ask the court to take mandatory judicial notice of the child's birth certificate, which the child did, which the court did. Okay? This is a request for permissive judicial notice in the event that the door opens. I'm not going to be throwing things at a jury. I would ask the court, Judge, can we introduce this at this stage if the state has opened the door on this issue? So, no, it's characterized right in the plain language of the motion itself for permissive notice, and that would be done with the court and with the state.
Oh, to that extent, the request is granted.
Thank you, Judge.
Is there anything further?
As far as my request that these items be proffered outside the presence of the jury before they're just referenced and marked in their presence, is the court agreeable to that?
You have any objection to that, Mr. Wiggs?
No, Judge, and I assumed we would do that. You know, I'm not just pulling things out and throwing at a jury. We would discuss it at the bench.
All right, without
Okay.
objection, the state's request is granted.
Thank you.
Thank you.
I believe that addresses all the matters before the court today. Is there anything further before the court?
The judge, yesterday I had referenced the preliminary jury instructions as far as the two alternate portions from the standard that talk about devices, and I just wasn't sure if you had made a decision on which one of those two alternates that you wanted me to put in the instructions to present to you for the preliminary.
Yes, sir, and I believe it would be best to exclude any devices from the courtroom.
All right, so that would be option B, I believe.
Option B, yes, sir.
Yes, sir. I'll make that change, email it to everyone. I've received Mr. Wiggs's proposed jury instructions, and there are some special instructions in there that we'll have to address at some point whenever the court feels it's appropriate.
Right.
All right, we can address that
Just
prior to trial or during trial.
Right. Just going back, just to clarify the record too, with regards to my motion in opposition to the state's request for a jury summary, in that I had cited Smith versus Carlisle. I had given the state that, and the decision is 378 Southern 3rd at 1213. The state had complained they didn't have a copy of any of